Hey everyone, and welcome back to This Explainer. Today, we're doing a highly requested update on contract damages. We're going to decode the black-letter law, dig into some classic case briefs, and test those legal instincts of yours. You know, if you've ever wondered how the legal system actually translates broken promises into cold, hard cash, well, you're in exactly the right place. Let's look at the rules that govern who pays what when a deal totally falls apart.
Okay, here's our agenda for today. First up, we've got an introduction to damages and foreseeability. Then we'll hit the duty to mitigate, followed by lost volume sellers, and finally, we'll wrap the whole thing up with substantial performance and waste.
All right, Section 1, Introduction to Damages and Foreseeability. Let's categorize the specific financial harms that flow from a breach contract and see what's actually recoverable.
So the law basically splits financial harm into three distinct buckets. First, you have standard damages. This is just your market price variance, literally the direct difference between what you were promised and what it costs right now. But then we have consequential damages. These are the secondary losses happening completely outside the immediate contract. Things like lost future profits. And lastly, incidental damages. Those cover the immediate reactionary expenses of dealing with a breach, like say paying to store rejected goods. Let's put this into perspective with a practical example. Imagine a fish market abruptly breaches a $1,500 contract to supply a caterer with seafood. Because of the super short notice, the caterer just can't get enough substitute fish in time. The event is completely ruined, and the furious client refuses to pay the caterer their massive $5,000 fee.
So here's a question for you. Can the caterer legally force that breaching fish market to pay for that entire $5,000 secondary loss? Or are they strictly limited to just the $1,500 value of the fish? It really makes you think about how the law balances this kind of cascading chain of financial ruin, right?
Well, this exact scenario is governed by the famous Hadley v. Baxendale foreseeability limit. The black-letter law here is crystal clear. Those secondary consequential losses, they're only recoverable if the fish market actually knew or, had reason to know about that high-stakes catering event when the contract was originally signed. If the market just thought they were selling a standard everyday order of fish, there's no way they're on the hook for that $5,000. Moving right along to Section 2, the duty to mitigate. This is all about minimizing losses once a breach actually happens.
Enter the doctrine of avoidable consequences. This is a totally foundational rule. Basically, it bars an injured party from recovering damages for losses that they could have avoided just by using some reasonable diligence. Think of it as a shield for the breaching party. It stops victims from just intentionally sitting idle, letting their losses stack up, and then handing the guy who breached a massive inflated bill. Now, take a look at this original court document. It's from Shirley MacLaine's incredibly famous 1970 legal showdown with 20th Century Fox. This case is a perfect illustration of the tension between mitigating damages and, well, protecting an employee's career and artistic integrity. Here's the setup. Fox canceled MacLaine's starring role in a feminist musical called Bloomer Girl. Now for that, she had a guaranteed $750,000 payout, plus director approval rights. But to avoid paying her damages for the breach, Fox offered her substitute employment, a dramatic western called Big Country. The catch? It was filming all the way in Australia, and importantly, it completely stripped her of her director and screenplay approval rights. Okay, before I give away the ending, what do you think? By outright rejecting that western role in Australia, did MacLaine legally violate her duty to mitigate her losses and save the studio money? Or was she completely justified in turning it down?
Well, the California Supreme Court firmly said absolutely not. She didn't violate her duty at all. The rationale here is that an employee has an absolute right to reject alternative work if it is of a different or inferior kind. A dramatic western in Australia with stripped rights was, for sure, distinctly inferior to a feminist musical with full creative control. So Fox had to pay her the full $750,000.
That brings us to Section 3, Lost Volume Sellers. We're going to look at a really fascinating exception to the mitigation rule we literally just talked about. So what is a lost volume seller? It's a unique entity with virtually unlimited resources, inventory, or production capacity. We're talking about a massive retail warehouse or a high-capacity telecom provider. They aren't just selling one thing at a time, they're selling to everyone, simultaneously. But you can't just claim this status to escape the standard duty to mitigate. You've got to pass a really strict three-pronged test. First, you have to verify you had the physical capability to perform both contracts concurrently. Second, you have to show that the secondary contract would have yielded a clear profit. And third, you need to prove you had the subjective intent to continuously expand your sales completely regardless of any breach.
Now, why do you think the courts let these specific sellers completely off the mitigation hook? Like, why shouldn't a massive corporate retailer have to deduct the money they make from the next customer in line?
The rationale here comes down to pure math. Because they have unlimited capacity, they would have made that second sale anyway. Forcing them to subtract the profit of a subsequent sale from their damages would unfairly punish them. It would actually deprive them of the two distinct profits they would have earned if the original contract had just been honored in the first place.
Finally, let's head into Section 4, Substantial Performance and Waste. This is where strict rules clash head-on with economic reality.
The substantial performance doctrine is a wildly important black-letter law. It essentially stops property owners from using minor, totally accidental variations in a contract to just escape paying their bills. Normally, if a contractor messes up, the damages are the cost of replacement. But this doctrine says that if the cost of replacement is grossly disproportionate to the actual good attained, well then, the damages shift to just the mere difference in market value.
Let's break this down with the notorious PV House case. A coal company leased a farm for strip mining and explicitly promised to restore the land afterward. But they willfully breached that promise. Expert testimony showed that moving the massive amounts of dirt required to restore the land to its original state would cost the coal company roughly $29,000. But wait, here is the other side of the math. Actually completing that $29,000 dirt work, it would only increase the total market value of the PV House farm by a measly $300. So the restorative work was completely, wildly disproportionate to the actual economic benefit it would create.
So, based on the rules of substantial performance we just reviewed, how do you think the court ruled on this massive financial discrepancy? Did they honor the exact, literal words of the contract, or did they bow to economic reality?
The court awarded the PV houses just $300. Their rationale was that forcing the $29,000 cost of performance would be grossly oppressive and cause unreasonable economic waste. Because that restorative clause was considered merely incidental to the main purpose of the contract, which was mining coal, the court capped the damages at the actual diminution in property value.
But I want to leave you with this final, kind of provocative thought. If willfully breaking a promise saves a corporation $29,000, but only costs them $300 in court, who truly benefits from the structure of contract law? Are these black-letter laws purely protecting us against economic waste, or are they really just providing an escape hatch for those with the most leverage? Think about it. Anyway, thanks so much for joining me today, and I'll see you in the next explainer.